Hello, everybody. Welcome back to Perspectives. To our followers, thank you so much for tuning in, and to our new listeners, welcome. On Perspectives, we discuss a variety of human resources and industrial relations topics within the workplace from both a millennial, me, and a boomer, John, points of view. We discuss topics like the ongoing global pandemic and employment, human rights in the workplace, health and safety measures, labor relations, unionization, and so much more. So today we're going to dive into the world of employment contracts and how employers should put themselves in the best possible position right from the start of any employment relationship. So what types of terms and conditions should be involved? Can and should you input a COVID-19 measure or a clause within your employment contract? What does your termination clause say? Do you even have a termination clause in there? How long or short do they need to be? And ultimately, why this is one of, if not the most important document you can have within your company. So John, to start us off, what do you think constitutes a strong employment contract? What sorts of terms and conditions would you include?
Thanks, Joss. And these are always interesting conversations to have. I think we probably have to go a little bit back to the beginning here when we talk about employment contracts. And, certainly over my 40 years in human resources, we've worked for the most part in the earlier years with offer letters of employment to individuals. In some cases, we'd have employees sign off on them. In other organizations, it was just strictly an offer letter. And by virtue of them appearing for work, that became the contract. So the offer letter then started to expand further into other areas as well. So it took us into the world of providing for some termination relief. Why? Again, to guard against what otherwise would be common law disputes. And we'll talk, I think, a little bit more about that issue versus minimum standards and statutory obligations. But included in there, we got into other areas. So we also got into non-competes, non-solicitation obligations. And it really then started to mean, who do we apply it to? Does that mean every person who's ever hired has all of these provisions in it? And I guess my answer to that would be no, not necessarily. So as an example, if you have an hourly employee, I'm not convinced that you necessarily have to have an employment contract. And part of the issue around the employment contract is, what is the likelihood that you will have to actually enforce it? From a legal perspective, and I'll leave it to our lawyer colleagues to speak more about this, they would obviously like to have an airtight contract at all times. The danger with airtight contracts is they become voluminous. Number one, they're then going to be exposed to the scrutiny of that employee or that prospective employee's lawyer to look at, make comments on, and you get into a lengthy negotiation process as what should that employment contract look like in order to ensure that the power between the employer and employee is properly exercised. So we try to do as best as we can to simplify the process, take into consideration what types of positions we should consider for employment contracts, and really trying to, I guess, as much as possible, make it as clear as possible to employees what their rights are going to be.
Well said. I think that's all very true. To John's point about our legal colleagues and about a legal perspective, I mean, this podcast and this kind of video vlog just kind of talks about human resources issues presently and just kind of gives our perspective on it. But should you want a legal perspective, please reach out to our legal colleagues at Shared Coups. I'd really like to bring up something that you touched on, which is the distinction between employment standards and common law. So John, could you explain that distinction?
Okay. So because for the most part, employees in this country, about 90%, are in fact covered under provincial legislation, contrary to what some people believe it's under federal legislation, the Canada Labor Code, you have to take a look at each provincial statute. And you'll find that in every province, there's provision made for some form of termination provision as a minimum. And so we are faced with what constitutes with notice, what constitutes with cause in each particular case. And each province has its own provision as it relates to with cause or with notice, because the notice obligations actually are different from one province to another. So the minimum standards are there. The common law is an overarching provision. Basically, everyone has the right to sue if they believe that their rights have been violated. And that could be in terms of enforcing an employment contract. It could constitute a constructive dismissal, which also could trigger a potential legal dispute because the employer unilaterally changed terms and conditions of employment to the detriment of the employee. So they've got all forms of recourse available at common law as well. The major distinction that I would say is under employment standards or labor standards, depending on which province you're in, is that when they invoke their rights under the minimum standards, it's not going to cost them anything because it's a statutory right and the government is going to work basically on behalf of an employee. On the contrary, if you go common law route, you will have to enlist the services of a lawyer and you're going to have to go through what might otherwise be a very protracted length of time in order to get due process.
Excellent explanation. I want to jump on that because there was recently a case in Ontario that came to a very harsh reality for an employer here. So in the case of Waxdale versus Swagan, this happened in 2020, a troubling decision came out as a result of an ambiguous termination clause in an employment contract. So the Ontario Court of Appeal ruled in favor of the terminated employee. What happened was Waxdale was terminated for a just cause termination, meaning that he was not entitled to termination pay. However, because the entire termination provision in the contract was not accurate in accordance with employment standards, it made the entire contract null and void. Therefore, the Ontario Court of Appeals agreed that the notion that Waxdale's the lack of termination provision being clear and cut means the entire contract was void and that notice pay was to be entitled to Waxdale at common law. To John's point, it's a lot higher than employment standards because you have to get the law and the legal community involved. So what does that mean? How do you avoid this? Well, one thing you can do is you can use the exact wording within the employment standards or labor standards, depending on what province you are in, on what exactly constitutes a termination with or without notice. So employment standards in Ontario, for example, the Employment Standards Act reads, certain employees are not entitled to notice of termination or termination pay under the ESA. Examples include employees who are guilty of willful misconduct, disobedience, or willful neglect of duty that is not trivial and has not been condoned by the employer. If you put that right into the employment contract, there should be no ambiguity or misunderstanding. So that's just one example of something that is important. So it's always important to include a termination clause in your contract. Don't omit that, because if you do, then it results back to the common law notice, because technically there's no employment standard provision in there. Right, John?
That's right. I mean, and it takes us back to, let's call it risk management for a moment. You know, the likelihood of somebody suing you in the past was probably a whole lot more remote than it is today. What we're discovering now is that given the world that we're in with COVID-19 and the pandemic, people are actually starting to view their rights much more seriously as they're without income. So many people are without income. And they're now seizing on every opportunity they can in order to have their rights, in fact, protected. And so they will be reaching out to lawyers and to represent them on this matters such as what we're faced with right now. So the common law obligation, I think, is going to be put more and more under the microscope, and it's something we're going to have to be contemplating. To Johnson's point about what should that employment contract contain, I think this is where we're probably going to deviate a little bit, and rather than giving you an exact amount of pieces of information, I do want to suggest that this is going to be reviewed in much more detail. So as an example, if a provision is in there that speaks to greater than what the employment standards is or labor standards, then that in itself might already be protective in terms of being able to not be sued, if you wish, successfully by a former employee. Because that employment contract, in effect, it becomes almost a release. You know, at the time that it's signed, that's going to be your first item of defense in the event that you are being sued, because you're going to say this employee voluntarily signed off on this particular contract. So the language itself and what provision you make for termination becomes really, really important. The jury is out right now in terms of what should it really look like. This issue around severability, the nullification of the entire contract if one piece is not working properly. These are all considerations as well. And my immediate thought would be that when you are looking at trying to protect yourself, recognize that there's a chance that you are going to be exposed to a common law dispute at any moment in time. Certainly recognize that from an employment standards that at minimum, that's what you have to provide for. And even if you do not have the termination provision, that does not prevent you from still paying nothing more than what you would otherwise under employment standards. In Ontario, it's important to recognize that there's a provision under the Act which actually clearly stipulates that an employee has to choose which avenue they want to take. Are they going to go the employment standards route, or are they going to sue you? They can't do both. So even an employee has an obligation here as to how they want to have their rights enforced. And remember, from an employment standards point of view, you're going to have the Ministry of Labor actively involved with that employee to seek relief. In other words, that the minimum standards are enforced. And the alternative is going to be to go and seek out legal support, which is going to result in, as I say, a protracted period of time before, in fact, it would find its way to court.
Yeah, all very true. I think, I kind of want to switch gears a little bit. The termination clause, while it is one of the most important parts of an employment contract, John mentioned earlier that there are some other provisions that should be included. What about the lighter side of employment? Like, would you put something like a dress code or a COVID measure in an employment contract?
Yeah, because an employer has a right to promulgate reasonable rules, if you wish, as long as you're meeting that test of reasonable rules, I would rather not put them into the employment contract itself. I'd rather have them as part of a policy manual that I would expect an employee to be reading before they start employment, so that they understand that this in fact becomes part and parcel of their agreement to join that particular organization. But when we talk about employment contracts, I don't think of it in terms of the legal document that would otherwise be produced by a law firm itself, which, as I say, could be fairly lengthy, fairly detailed, in order to protect against any type of litigation. I would like to suggest that the employment contract is supposed to be invitational. It's supposed to be a little bit upbeat. You're welcoming somebody into your organization. You're trying to share with them what, in fact, all the good things are that you will be doing for them. And we don't want to lose sight of that component as well.
Yeah, I think that's really important because, John mentioned as well about the minimum standards, and you can't opt out of minimum standards regardless of what your contract says. Like, you're inviting somebody into your second home. You want to make sure they feel welcome, and that, first of all, the contract is legal, that you're not opting out of anything minimum, making it illegal. But you also want to attract and retain good people, and having a good employment contract with both the termination provision or, vacation or benefits. Those are all things that are inclusive, but you want to make sure that people feel welcome in your organization and they feel excited about starting. So maybe including a couple of those lighter things might be a good strategy.
I'd like it to be a warming document, to be very honest. We're going to try to introduce things such as a non-compete, a non-solicitation provision. The non-compete you have to be so very careful with, because people still have the right to seek employment in the event that they lose their job. The non-solicitation of customers and employees, that's a lot more rigid, and in fact, employer can seek some real serious relief. In fact, there's a lot of solicitation underway on the part of a former employee.
Yeah.
But it really is, again, a document that we want to be a little bit uplifting, and it's one that we want to make it invitational for employees to want to join us. The timing of this is also equally important. In other words, you do not give the person an employment contract on the day they start their employment. Remember, this is intended to be a balancing act between the employer's rights and the employee's right, because the employer has the power under normal circumstances. And the only way that power can somehow be mitigated by a prospective employee is that they have enough time for considering their employment contract, that they have the opportunity to, before they quit their job, as an example, to look at the document, that they have the opportunity to seek out independent advice, however that may be obtained, whether it's through a law firm or whatever. But you really want to make sure that it is not on the day that the person reports work and say, here, sign this. Never do that.
All right. Well, I think on that note, we're gonna end this quick little vlog or this podcast. Thank you so much, everybody, for listening. Your perspective and feedback, John, is always exciting and interesting. We discuss these types of things through our various social media channels as well. We also post important updates. We post promotions that HRIR is having. So as an example, if you would like a template of an employment contract, we have them available. We also post various like management materials and other important human resources initiatives. Follow us on Facebook, LinkedIn, Twitter, and YouTube to hear about more. So thanks, John. Stay healthy and stay safe.
Thanks, Joss.